All right, I want to welcome everyone for this nice turnout. My name is John McAllister, and I'm part of the business development team here at Baird. On behalf of your Baird advisors, I'd like to welcome you to this Baird Wealth Strategies webinar entitled Plan Your Legacy, the Essentials of Estate Planning. In this webinar, two of our estate planners, Jessica Bell and Darian Ornado, are going to guide us through the basics of estate planning, from titling assets to designating beneficiaries, all the way to potential legislation and tax implications, and all that may impact your estate plans. Regardless of where you are on your journey, we know you'll find this presentation worthwhile. Before I turn the call over to Darian and Jessica, I have a few housekeeping items I'd like to highlight. For optimal viewing, we suggest setting your layout to the side-by-side view via the circle in the upper right-hand corner. All participants are in listen-only mode, but we'd love to hear from you. To that end, we will host a Q&A session at the end of the call to address as many questions as time permits. And you can submit a question by clicking on the Q&A icon, which hopefully you see in the bottom right-hand corner. Please be sure to address your questions to all panelists. And finally, this presentation is being recorded and will be available to you via your Baird Financial Advisor about a week following today's call. So plan on next Wednesday availability. With that, thank you for joining us today. I'll now turn the call over to Darian. Darian, the floor is yours.
All right, thank you, John. Hello, everyone. My name is Darian Ornado. Again, I'm an estate planner here with Baird. Thank you for joining us on the call today as we explore the essentials of estate planning. So estate planning is the process of organizing and arranging your assets to help ensure that they're transferred according to your wishes upon your death. Creating a comprehensive estate plan can help protect you, your assets, and your loved ones, and most importantly, give you peace of mind. So today, Jessica and I are going to walk you through asset titling and beneficiary designation structures. We are going to define what a base comprehensive estate plan looks like. And we're actually going to go through our estate plan discovery workbook that we have available here at Baird through your financial advisors. And then we're going to talk about the One Big Beautiful Bill Act and its impact specifically on estate planning. And then we're going to open it up at the end so you all can ask any questions about the information that we give you here today. All right, so I'm first going to start off by talking about asset titling and beneficiary designation structures. So today we're going to talk about two different types of titling designation. So accounts that go through probate and then accounts that will avoid probate. So first, I want to talk about what is probate, if you don't know what that is. In estate planning, probate is the exciting process of the court managing and distributing a deceased person's assets. It involves proving the validity of a will, identifying and valuing assets, paying any debts or taxes owed, and then at the end, it's distributing all of the remaining assets to your beneficiaries. Now, probate is based on the laws and procedures of the state in which you reside at the time of your death. This means that probate can look a little bit different depending on where the assets are located and is different from state to state. If any of you have been through probate or experienced probate with a loved one, you know that it can sometimes be a lengthy and costly process. And because of that, people want to try to avoid probate. Now, first, I'm going to talk about accounts that would have to go through this process, this probate process. And that would include individual accounts and accounts that are titled joint tenants in common. Now, individual accounts are accounts that are titled solely in the deceased person's name, without any designated beneficiaries. So this would include things like bank accounts, checkings and savings accounts, investment accounts, and potentially business interests. And then joint tenants in common, if you're not familiar, it is a type of ownership where two or more individuals own an asset together, but there's no right to survivorship. So what this means is at the death of one owner, that owner's share does not automatically transfer to the surviving owners. Instead, it becomes part of their probate estate and has to go through that probate process that we talked about. Now, as I mentioned before, people would like to avoid probate. So there are a few ways to do this, even with these types of accounts that would usually go through probate. So for example, on individual accounts, there are sometimes the option to add a payable on death, which is also known as a POD, or a transfer on death, known as a TOD designation. What that means is you would designate a person or persons that would inherit your asset, so the investment account, the bank account, and then that asset would pass directly to that person upon your death, bypassing the probate process. So that's kind of one way to avoid probate with individual accounts. Now, going back to joint tenants in common, although that generally passes through probate, if the asset is owned by a revocable trust when you die, then that asset can avoid probate and be distributed via that trust document versus the court. Now, I'm jumping ahead a little bit. I will talk a little bit more about revocable trusts later, but I just wanted to mention that this is a way for joint tenants in common to avoid probate. Next, I'm going to talk about the accounts that do avoid probate. So, like I said, joint tenants in common can avoid probate through going through revocable trust. We'll talk about that next. We went through individual accounts with the TOD and POD designation. So next we have joint tenancy or joint ownership with rights of survivorship. And so this type of ownership is usually spouses, but doesn't have to be. Here, both owners own an equal share of the asset. So when one owner dies, their share passes to the surviving owner or spouse without going through probate. So all you need here is a death certificate, and then that share can transfer to the surviving owner. Now, something to keep in mind with this type of ownership is if one joint tenant incurs a debt or is sued, then their creditors can pursue the jointly held property to satisfy that debt. So an example of this that we see here in our practice is parents deciding to co-own property or assets with their children, right? Usually to avoid probate. Later on in life, the child either faces bankruptcy or is in some other type of lawsuit, and then the child's creditors will place a lien on that property or that asset. Now, even though the parent is the one who contributed all the funds, the asset can be taken at no fault of the parent. So in this situation, we usually recommend using beneficiary designations instead of co-ownership to avoid the probate process. The next type of titling designation is tenants by the entirety. So tenants by the entirety is very similar to joint tenants with rights of survivorship, but it's only available to married couples and it is state specific. So in this form of property ownership, each spouse owns the entire property instead of just a share. But unlike joint tenants with rights of survivorship, tenants by the entirety offers creditor protection. So this means that the creditors of one spouse cannot take or force the sale of property to satisfy one spouse's debt. Now, this makes tenants by the entirety the superior titling designation. The only problem is that not all states recognize it. It's only offered in about half of the states in the US. So you want to check your state specifically if they accept tenants by the entirety as a titling designation. Now, earlier I mentioned we talked about joint tenants in common in relation to revocable trusts and how those can avoid probate. So now I'm going to really dive in to what that means. You can see here at the bottom of the page, our last three bullet points are individual revocable living trusts, joint revocable trusts, and irrevocable trusts. So these are all type of trusts. What I want you to know is that anytime you have a trust, be it revocable or irrevocable, that asset will avoid probate. And the reason that asset avoids probate is because it's owned by the trust and not by you individually. So I'm going to start by talking about what each type of trust, how they work and what they do. An individual revocable living trust is, like I said, it's also known as a living trust, is a legal document where you as the grantor transfer assets into the trust while retaining the power to modify it while you're still alive. So what this means is you put your assets in the trust, you have access to those assets, you can change beneficiaries, you can take assets out of the trust, you could even get rid of the trust entirely if you wanted to, as long as you are if you are sound of mind. Ultimately, the trust is its own legal entity, so it's separate from you as an individual. So when you die, the assets are not part of your estate. Therefore, nothing needs to be probated. Instead, what happens is when you die, the successor trustee that you appoint is going to distribute your assets to the beneficiary according to the instructions inside of that trust. Now, trusts are a very popular estate planning tool, not only because they avoid probate, but they allow for flexibility in managing your assets. They can allow for control of the assets long after you're gone. And unlike probate proceedings, this type revocable trusts are completely private. So none of your information or your estate would be available to the public like it would be if it went through that public probate proceeding. Now, you can see here we have individual revocable living trusts and joint revocable trusts. Now, a joint revocable trust is created by two individuals, usually a married couple, and it holds their combined assets, where an individual trust would be created only by one person and would hold only that individual's assets. Now, as a married couple, deciding if you want individual or joint trusts will really depend on your specific circumstances and preferences. Individual trusts allow each spouse to control their own assets and tailor the plan to their specific wishes. They can also shield assets from creditors and can be beneficial in cases where you have high-risk professions or blended families or second marriage situations. Although, these are the pros, they can also be more complex and require more effort to execute and manage. So some people will opt for joint trusts. And joint trust will combine the assets of the spouses, and it can be used in situations where couples have joint goals and integrated finances. So creating and managing one trust can usually be less expensive and easier for some couples, but you along with your attorney would decide what option is best for you. So the last type of trust on this page, an account that avoids probate, is going to be an irrevocable trust. And so unlike a revocable trust that we talked about, these types of trusts are generally cannot be modified or revoked after they are established. So unlike revocable trust, once you set up this irrevocable trust and you transfer your assets into that irrevocable trust, you lose control of that asset. Now, the reason people create irrevocable trusts and accept that loss of control is because you can gain significant asset protection, and there are also tax advantages to irrevocable trusts. I'm not going to go that far into irrevocable trusts, but I just kind of wanted to point out the differences and indicate that these are the type of titling designations that would go through and avoid probate. So next, I'm actually going to move on to beneficiary designation. So beneficiary designations are another way to avoid probate outside of your initial estate planning document. So what you would usually consider like your will or your revocable trust. The first I'm going to talk about is that for non-qualified assets is the transfer on death or payable on death that we discussed a little earlier. If this is offered on a non-qualified asset, you can opt in to designate a beneficiary that the asset will then pass to, avoiding probate at your death. Next, we have qualified accounts, things like IRAs, 401ks, life insurance, and annuities. These beneficiary designations on these accounts will determine who receives the accounts after you die. So things to know here. If you leave this blank, or let's say you leave it to your estate as the beneficiary, this is just going to drag the account back into probate. So you either want to list an individual or your revocable trust or something like a charity in order to make sure that it avoids probate. Now, it's crucial to keep this information up to date and to just make sure that everything and your beneficiaries align, especially after major life events like marriage, divorce, or birth of children. Now, if you decide to create a revocable trust, and then you choose to list the revocable trust as a beneficiary specifically of an IRA account, you need to know that in general, when you leave an IRA to a trust, the IRA is going to have to be withdrawn within 5 years and the taxes are going to have to be paid on it. There are lots of exceptions to this. In many cases, the initial 5 years can be extended to 10 years, and in some cases, it can be stretched out even further. I'm not going to get too far into that because that is a whole nother discussion related to the Secure Act, but I just wanted you to be aware that if you're leaving an IRA to a trust, there are some rules that we have to talk about and some things we have to consider in terms of the payout. Now, trusts in general contemplate the sequential order of death and how the beneficiary should receive their share either outright or retained in trust. So sequential order refers to where the asset would go if the beneficiary dies. There are two places it would go. So the first is per capita, which basically means if the beneficiary dies, their share would then be transferred to the remaining beneficiaries if there is any, or to the estate if there's no remaining beneficiary. And then there's per stirpes, which means the assets would pass to the deceased beneficiary's children. Now, an example of this would be if you have an IRA account and you have your children, you have 2 children, and they're both listed as 50-50 beneficiaries of this account. If they're listed beneficiaries per capita, what that means is if one of your children dies, their 50% share will go to your remaining child, okay? Now, per stirpes, regardless if they have children or not, if you decide to list it per stirpes, what that means is if one of your children dies, their 50% will then pass to their living children, and your other remaining child will only receive their 50%. So this is really important to consider, and it's very important to know what the default designation is at the institution where you have your money. Something to know here at Baird, the default is per capita. So if you don't designate specifically per capita or per stirpes, it is going to default to per capita. So you just kind of want to know that going through it, and it's something to think about when you're looking at your beneficiary designations. The other thing to consider is leaving beneficiary designations. It contemplates how the beneficiary will receive their share. So there's different ways to leave assets to an individual, either outright or retained in trust. So outright means that the beneficiary will have full control of the asset. It is theirs to use or abuse as they see fit. If that worries you and you want to have more control of the assets or provide asset protection to the beneficiary, then you'll probably want to consider keeping those assets in trust for the beneficiary instead. When you keep assets in trust, the beneficiary will have set parameters on how they can use the income and principal in that trust. And you also get to decide who's going to oversee distributing those assets. That's called a trustee, and you get to pick that person. Now, for beneficiary designations overall, something very important that I want you to remember is that beneficiary designations override your estate plan. So if you update your plan, you want to update your designations to make sure that they marry each other or are accomplishing your ultimate goals. Unfortunately, we have run into the issue where clients have set beneficiaries and then people pass away or people are born and they never update those beneficiary designations. Then they die and those assets are either going against their wishes or those assets are having to go through probate. And so as important as it is to keep up with your estate plan, it's as important, if not more important, to make sure that your beneficiary designations are updated as well and are accomplishing your goals. Now, here is talking about, as estate planners here at Baird, we can review your plan. We can help you figure out what it is you're looking to do. If you don't have an estate plan, explain your estate plan to you and just look at it overall and make sure that it's accomplishing what you want it to. But in order to do that, we ask your planner for a net worth statement, and that's very important. Within the net worth statement, we need the information regarding the type of assets you have, the titling of those assets, the beneficiary designations, if any, then obviously your estate plan review document. So if you have an estate plan in place, we want to see those documents drafted by your attorney. Now, we want to see all these things to make sure that everything matches up and is doing what it's supposed to do. So if your advisor is asking you for a lot of information, just know that it's so we can provide you with quality advice and considerations and make sure that this plan is doing what you want it to. Now, there can be global coordination done through beneficiary designation. So there are times when clients either don't have estate planning documents, or we don't have to touch their existing estate planning documents. We can just update beneficiary designations to reach their ultimate goals, so that it makes it a little bit quicker process, making sure we're looking through those beneficiary designations often and making those changes. But something to keep in mind is that risk remain if the beneficiary designations are the only thing looked at, right? Because that may overstate or understate your intentions. We really want to talk about what you have listed and look at it in relation to your estate plan, if you have one, to make sure that your goals, like I said, are being met. The worst thing that can happen is that you spend the money to create this beautiful estate plan and it does exactly what you want it to, but then your beneficiary designation that override that estate plan are doing something else. So really it's not a formula. We just need to look at all your estate plan, all your estate documents, as well as that information that I talked about on at the top of this slide, to really understand what's going on and make sure that it's doing what you want it to. Did you know? So did you know that everyone has an estate plan? So if you're sitting here today and you've talked to your attorney, that is your personal plan, right? You have your will, you have your irrevocable trust. It does exactly what you want it to do when you pass away. Now, if you're sitting here today and you're saying, wow, I haven't done that, I don't have an estate plan. You actually do. Everyone has an estate plan. You either did it yourself or the state did it for you. And what that is called is intestate succession. So what that means is the state will basically decide where and how your assets are going to be divided with when you die, if you don't. Most people like to have a say in what's going to happen to their assets. So today we are going to talk through that, what an estate plan looks like, what the comprehensive documents are. And Jessica, I'm going to hand it over to Jessica to start that conversation.
Great. Thanks, Darian. Great job. So now we're going to talk about the items of a comprehensive estate plan. And we'll move to the next slide. The items that are included are typically a last will and testament, an individual and/or joint revocable living trust, a marital property agreement according to your state, a durable power of attorney for finances and real property, a healthcare power of attorney, a living will, a HIPAA authorization form, and then often included is an authorization for final disposition of remains. And we have an estate planning discovery workbook that you can reach out to your Baird advisor to obtain. And this helps walk through all the information and explains every document in detail. So we're going to walk through that right now. And here we go. All right, so this workbook is designed to gather the information needed to support the conversations with your estate planning attorney. When you receive it, it's an editable PDF, so be sure to save it first to your device before filling it out. And you may think, we're going to move to the next slide. Pages 2 through 6 really cover a lot of the things that Darian talked about earlier. We ask about your assets, your personal information, and your overall goals. And so just keep in mind that, like she said, we need to have this information in order to make sure we coordinate Baird assets appropriately with your overall estate plan and help give guidance and recommendations for you to take to your attorney. You're going to have to fill all this out for your attorney anyway, so let's just go ahead, do it now, and save a step when you go to your attorney. So we're going to skip to page 7, where we list those items again that I mentioned earlier. So, and these really vary from person to person, but these are what I'd say are most typical. So then moving on to page 8, first we'll talk about a last will and testament. So as Darian just mentioned, if you don't have an estate plan, the government has one for you, and any assets that do not pass by beneficiary designation or operation of law pass through probate as an intestate estate. So if you don't mind probate, and that state mandated split is what you choose anyway, this might be fine for you. But a will allows you to direct where those assets go and who is in charge of settling your estate. Your executor is the person that's in charge of settling your estate, and your executor is in charge of gathering your assets, paying debts, taxes, and final expenses under the supervision of the court before distributing out those assets to your named beneficiaries or to the trustee of your revocable trust. As we mentioned, probate is a public procedure in that anyone can request a copy of the file from the clerk of court. This may matter to you, this may not matter to you. A will also allows you to name guardians for your minor children. So the first question people have is, who do I appoint as an executor? I recommend that you appoint someone who is trustworthy and responsible, who has great attention to detail, will respond to notices from the court, will communicate with the beneficiaries, and I like to see at least one primary executor and 2 alternates. And then for parents of minor children, and this is often the most difficult question, who do I appoint as guardian for my minor children? So the factors you want to consider are someone who is going to be around until your children are 18. Often grandparents are named when the children are very small, but are they the right ones to continue in 10 or 15 years? You can also revisit this down the road as well and change it. If you name a couple as the guardian, think about what happens if one member of that couple dies. Do you want the surviving person to be the remaining guardian? This person is in charge of where your children live, where they go to school, medical care, and extracurricular activities. This is not necessarily the person in charge of the money. That's handled separately. And I'll note here that whether you have a will or a revocable trust, do have it create a trust for your minor children at death and name a trustee to manage those assets. So a note about the probate process. Historically, ease of probate varied from state to state, and I'd say it still does to a large degree. But what we've found is that even in the states that have historically been easier, the process has gotten longer and more time consuming in the last 5 years, really since the COVID era shutdowns. So now there is a special type of will called a pour over will that is used in conjunction with a revocable trust. It directs the executor to pour over any assets that pass through probate to your revocable trust. It's typically very short and meant to capture anything that was not already titled in the name of your revocable trust. It may not be used at all or for a very specific purpose. So hopefully if it's used, it's just for a small estate or a DMV procedure. So now we'll move on to a revocable trust. And Darian mentioned this earlier, but it's worth repeating. A revocable trust is an entity you create to consolidate the ownership of your assets during your lifetime while also controlling the distribution of those assets upon your death. You can change it, modify it up to completely revoking it during your lifetime while you have the capacity to do so. It's really seen as an extension of you by the IRS. Therefore, you report your taxes the same on your 1040 under your Social Security number as you did before. Your Social Security number is typically your tax ID number. And because it is an extension of you, it by itself does not provide any asset protection from creditors. You need to use it in conjunction with something else. But the advantage of creating and funding a revocable trust is that you will reduce the expense, delay, and public record of a probate proceeding for your family. And funding is really important here, and you'll hear us say this several times. But because too often people create the revocable trust and they think they're finished, but you actually have to transfer your assets into that trust. So I have a 6-year-old, and true story, she came to me recently and said, "Mommy, what's a revocable trust?" And I said, "Oh, my darling, what a clever question. I'm so glad you asked." A revocable trust is a lot like a box, and everything you want to fund the trust is placed in the box. So all of your special treasures. It stays in the box until you take it out. The terms of the trust are like wrapping paper or stickers on the outside. And so maybe we want to have rainbow and unicorn wrapping paper. You can change that wrapping paper. You can change those terms at any time, but it doesn't change what's in the box. So your trustee manages what's in the box. And when you die, you can't change the wrapping paper anymore. It's locked in. So your trustee gives what's in the box either to the people or places you name, or they give the box to another trustee to manage for someone else. So now you know what a revocable trust is. Let's next consider who will serve as a trustee. So typically you are the initial trustee, though you don't have to be. And then you can name successor trustees who will take over once you cannot or do not want to manage your trust anymore. If you are incapacitated, your successor trustee will be able to manage those assets for you very easily. At your death, like I said before, your trust becomes irrevocable, meaning it cannot be changed anymore, and it will get a new tax ID number because it is a separate entity from you now. Successor trustee is responsible for making sure that the debts and final expenses are paid and that further distributions are made, but without any court oversight. So when you think about who to name as successor trustee, again, think of someone who is responsible, trustworthy, and will keep good records of everything they do. And also important that they communicate with your beneficiaries. Now, if you are feeling a bit nervous thinking about the potential people you have in mind, you may want to consider a corporate trustee. For example, Baird has Baird Trust Company, and Baird Trust could act in situations where you don't have a reliable person to act for you. A corporate trustee is good for complex situations because you have a professional team to manage everything. They're good for minimizing family conflict among the family members, and really also good for continuity when you name that corporate trustee at the end of the line, because a corporation will be here years down the road when all the people cannot or do not act. So if you want to know more about Baird Trust and the services they offer, reach out to your financial advisor. So now we're going to move on to a durable power of attorney. And a durable power of attorney gives your agent, also called an attorney in fact, the ability to make financial, legal, and business decisions for you. It covers assets that are outside of your revocable trust. Anything inside your revocable trust, your trustee continues to manage for you. Now that might be the same person. Your agent and your successor trustee and your agent might be the same person, but they're just acting under different authorities. Even if you have a revocable trust, it's important that you have a durable power of attorney so that your agent can sign tax returns, settle legal disputes, apply for benefits, and other transactions. A power of attorney is durable if the power to act continues after your disability or incapacity. But that power is only effective during your lifetime. Your agent's authority ends at your death. So there are two main approaches to designating a power of attorney. Most durable powers of attorney authorize an agent to act immediately, even if they would not and probably should not do so. But the durable language means that power does not automatically terminate if you become disabled or incapacitated. But do realize that that power is there. Some people call this live when signed. By contrast, a springing power of attorney becomes effective only upon your disability or incapacity. But note, this is often difficult to prove in a time frame that is helpful and in a form that financial institutions will accept. I've seen this take several weeks or more because under most state statutes, a doctor, not a PA, not a nurse practitioner, has to certify on letterhead that the principal is incapacitated, and that just takes a long time. So we've seen plenty of instances where the agent was not able to get that letter in time from the doctor, and that letter certifying incapacity, the principal passed away and important planning opportunities were missed. So one tip when you go to your attorney is when you get the drafts back, note that the scope of the power that you are granting to your agent can be very broad or very narrow, and even down to covering only specific types of transactions. So the very broad powers are what I would call wide open, which means the agent can engage in unlimited gifting, change beneficiary designations on your IRA or life insurance policies. And there are legitimate estate planning reasons why you would want to give your agent that broad power. But as you can imagine, this is where powers of attorney are most abused. So many lawyers will allow the overall broad powers, but place limitations such as the agent cannot disrupt the overall estate plan or keep any gifts for the benefit of the agent under a certain amount. So just make sure that when you're looking this over that you have a conversation with your attorney about it. This is not boilerplate language. It can absolutely be modified. So all of this begs the question again, who should be my agent? This is the same skill set that a trustee of a trust or executor under a will would have. Again, that attention to detail, keeps accurate records, responds to official notices. Your agent can always enlist tax and legal advice from a CPA and attorney, and really should do so they don't have to know everything. The most important factor is that they are trustworthy. So all of your agents, trustees, etc., are fiduciaries to you or your estate or your trust, meaning they must act in your highest and best interest at all times, not their own. There can be criminal penalties and civil liability for abusing this fiduciary power, but we don't want to get to that point in the first place, so just appoint someone you trust. So again, I suggest naming one primary agent and at least 2 alternates. And this is more of a preference, so discuss it with your lawyer, but I personally don't like to see co-agents on this document. In my practice, before I joined Baird, I had situations where large financial institutions refused to acknowledge the co-agents and made one of them to resign in order to honor the power of attorney document, even though there was language in the document that said they could act jointly or severally. Unfortunately, that left no successors if the only named agent could serve. So at Baird, typically this would not happen because our advisors know our clients and they know their families, but just keep that in mind. And again, discuss with your attorney. So now we're going to move on to page 11 with advanced healthcare directives. And the first type we're going to talk about here is a healthcare power of attorney. A healthcare power of attorney, or durable power of attorney for healthcare, is a document that appoints a trusted person to act as your agent to make healthcare decisions for you if you're seriously ill or incapacitated. It typically does not go into effect until 2 doctors say you can't make or communicate decisions, and your healthcare agent may approve medical care and treatment on your behalf. When you are thinking about the healthcare power of attorney, again, you want to appoint 1 agent, 2 alternates to make medical decisions for you. Unlike durable powers of attorney, I think co-agents are okay here because the process is much simpler because the doctors just really need to make a notation in your chart. The power to act, though, remember, does not become effective until that time. This power also typically ends at your death. So if you have strong feelings about certain treatments you do or don't want, you can list that in this document. The most important thing is that you have a conversation with your agent about what you do and don't want. Their power also typically ends at death, although you can give your agent authority over disposition of remains, or some states prefer a separate authorization for disposition of remains that we mentioned earlier. So I will note that if you wish to have anything other than a typical burial, you should write that in your healthcare power of attorney document or have that separate authorization for disposition of final remains. More and more people want alternative burials today, and state law hasn't really kept up with that. So if you want to be cremated, a green burial, aquamation, be sure to write that in somewhere. The next one we'll talk about is a living will, and we'll go back. A living will states what sorts of interventions or extraordinary measures you do and don't want at the end of your life when you have a condition that's terminal, incurable, and will result in your death in a relatively short period of time. You can choose to not fill one out and just let your agent under the healthcare power of attorney make the appropriate decision at the time. And I'll note, the younger someone is, the more difficult it is for them to contemplate these end of life decisions and what they do and don't want. So it's completely fine to let the agent make that call. And conversely, the older someone is, the more they have very strong feelings about what sorts of extraordinary measures they would and would not want. But the living will document helps prevent, and I'm in the South, so bear with me here, but what my medical friends call the drama and the trauma. So it removes the pressure from your agent on the decision. And I do recommend it if you have extended family members or friends who might disagree with what you want or that your agent would state on your behalf. So finally, a standalone HIPAA release can also be useful. Most healthcare powers of attorney have HIPAA language built in, but very often that HIPAA language is not triggered until the entire healthcare power of attorney document is triggered. And there may be times when you want the people you name to be able to access your medical information or have conversations with your doctor. So this is where a standalone HIPAA release can be useful. It does grant access to your information right away as soon as it's signed. And I also like to see these drafted to be valid 2 or 3 years after your death so that those people can go back and get medical information if something comes up down the road. So when we're thinking about the agents again, one primary agent, 2 alternates if possible, and someone who is responsible and trustworthy. We want it to be someone who will follow your wishes, even if there are other members in the family who will disagree. And I think it's helpful if they have a medical background, but I really only consider that a factor if you're trying to decide between 2 otherwise well-qualified agents. So for example, if you have one adult child who is an accountant and one adult child who is a nurse, make the accountant the primary agent on the durable power of attorney and the nurse the primary agent on the healthcare power of attorney. And I'll also add, since we're talking about young adult children, this is usually the first place where people add their young adult children as decision makers, really prior to adding them on to decision makers for the finances. So now we're going to move to the next page and talk about something that's only applicable in community property states, and that's a marital property agreement. So if you live in a community property state and are married, assets acquired during the marriage are generally considered joint property. And note, we have highlighted those states in dark green below. Note, this applies if you've ever lived in one of those states while you were married as well. So be sure to let your attorney know that information. A marital property agreement is a useful tool that can designate assets as either individual or separate property or marital property, joint property, regardless of how the assets are titled. And then moving on, we'll talk briefly about a tangible personal property memorandum. We can move that. So a tangible personal property memorandum lets you designate specific items that are to be given to a certain person, like family heirlooms. And as long as it's referenced in your will or revocable trust, you can change it or update it at any time without having to modify or amend your will or trust. Note, it is considered strong guidance for your trustee or executor, and they're not bound to follow it, but they generally always do unless there's a very, very good reason not to, such as the estate is insolvent and they have to sell everything. So we recommend keeping this memorandum with your will or revocable trust. I would print it out and sign it and date it every time you change it, or completely handwrite it. I've seen arguments happen when this memorandum was kept solely on a computer. And so now is a good point to talk about where to keep your estate planning documents once you have everything signed. We recommend storing them in a safe place wherever you keep your other important papers. This could be in a fire safe at home, as long as someone else has a combination, or in your desk with your other important papers. And electronic or scanned copies can be invaluable as well. You could also keep them at your attorney's office if that's a service they offer. They do usually charge for that storage service though. Just make sure wherever it is that your agents, that your loved ones know where to find them if needed. Some people store these in a safe deposit box at the bank, but I absolutely do not recommend that because your agent or executor will actually need those documents to access the box at the bank. So if you don't have that, then you have to go to court and get an order and drill. Ask me how I know. As you move through the estate planning process, you may have questions about any of these pieces. Your attorney and your Baird financial advisor are here to help you. So don't feel like you have to have everything figured out beforehand. Once your estate planning is in place, it is essential that you revisit your account titling and beneficiary designations, as Darian talked about earlier, to make sure they align with your overall estate plan. And make sure your revocable trust is properly funded. And don't hesitate to reach out to us if you have any questions. And really, you should revisit this every 3 to 5 years or with life changes anyway. So we have this discovery workbook, and there will soon be an accompanying video walkthrough available through your Baird financial advisor. So just reach out to them for assistance. So now let's turn to the One Big Beautiful Bill Act's impact on estate planning basics. So I think that is slide. Let's move forward to that part. There we go. All right, so I've heard some debate over how to shorten this name because it's a very long acronym. So I'm going to refer to it as OBA. Most of the changes in OBA impact wealth. Most of the changes we list impact wealth transfer strategies. So we'll talk about that as we move along. First, there's a certain amount that each person can pass to others during their lifetime and at their death without having to pay federal estate or gift tax. You just have to file a gift tax return to keep track of any gifts during your lifetime. In 2025, that number is $13.99 million per person. But OBA has updated that exemption, and it has risen now to $15 million per person starting in 2026. Now note that U.S. citizen spouses can always gift unlimited amounts to each other. But otherwise, gifts during lifetime and transfers at death combined must be less than that $13.99 million this year, $15 million next year. And then it's pegged for inflation. So a married couple combined will be able to pass $30 million estate and gift tax free to others. For historical comparison, this number was $1 million in 2003, so much, much lower. And a few states impose their own estate and gift tax with much lower exemptions. Those are not affected by OBA. But I will point out for those of our listeners in Washington State, contact your attorney or CPA because there were changes earlier this month to the state exemption, raising it to $3 million, but increasing the overall tax rate. So overall, with these elevated exemptions, basis adjustments become an even more powerful tool to pass on wealth. And although there were some proposals to eliminate basis adjustments at death, those did not pass. Basis adjustments are unaffected. And so you'll probably see people hold on to real estate or stock until death to get that basis adjustment instead of selling or gifting it late in life. So in addition to this lifetime exemption, Everyone can gift what's called an annual exclusion amount of $19,000 this year to others without it even applying towards that lifetime exemption number. Many people use the $19,000 annual exclusion to gift to younger generations through 529 accounts, UTMA accounts, and now there are some new options under OBA. First, 529 accounts now have more expansive definitions of what those funds can be used for. And OBA just created a new type of IRA savings accounts for children called Trump savings accounts. So just note that with all of these destinations, all the contributions combined must total up to $19,000 or less each year to fall under that annual exclusion amount. And there are some special super funding rules for 529s and certainly more information available through your Baird advisor on the Trump savings accounts and changes to the 529s. But overall, keep in mind that with these elevated exemptions, estate planning is still important, but factors such as asset protection, basis adjustments, and income tax planning are going to outweigh the estate tax planning that most attorneys formerly focused on. And so for a detailed discussion of those income tax issues, I want to invite you all to tune in to the special Wealth Strategies call next Thursday, July 24th at 12 p.m. Central, where our own Tim Steffen, Director of Advanced Planning, will talk through these concepts in detail for clients. And so with that, I think we are ready to move to any questions.
Great, Jessica, Darian, thank you so much for sharing your expertise. We have had some questions. Some have been answered directly, but I'll ask them so you can address them to the group as well. Just remind everyone that if you do want to ask a question, you can do so through that Q&A button on the bottom right side of your screen and address the question to all panelists. Question regarding the revocable trust and having its own unique tax ID. I believe you answered that. It uses the individual social security number until death, and then you do have to get a tax ID number.
Or your successor trustee will. Yeah, and
Yes.
You could choose another one, but there's not really, that just gets confusing. I don't know why you would do that.
Okay. We had a viewer ask, what happens in per stirpes if the deceased beneficiary has no children? Who does it go to?
I can answer that one. So if the deceased beneficiary doesn't have any children and you have another beneficiary listed, it will go to that beneficiary. If you don't have anyone else listed, then it would flow back into your estate if that child had no descendants.
And then it's going to be determined by what your documents say.
Exactly, if you have any.
Yes. Let's see, if a beneficiary designation overrides estate plans, where does one's will fall into the hierarchy? For example, does a will override beneficiary designation?
That's a great question. So no, a will does not override a beneficiary designation, but in regards to the will, it will cover any other assets that don't have beneficiary designations. For example, a home, right? So your home would go through your will, pass through whoever you had that to, and then anything that contained a beneficiary designation would pass separately. So it's not that they don't work together, but you just need to know that if you're in your will, you want all your assets to pass evenly between two children, and then you have an account with a transfer on death designation, but you only have one child listed, we may have to update that beneficiary designation. But overall, your will cover any assets that don't have beneficiary designations.
Okay. All right, another revocable trust question. What would I want to place within my revocable trust versus those things I should keep outside of the trust?
So anything that you want to avoid probate, you'd want to place in your revocable trust. And this is where I think coordination with your attorney and your financial advisor is key. Some things you cannot place in a revocable trust, such as if you have an IRA, you can't place that into the trust, but you can make the trust a beneficiary of the IRA at your death. But Typically, what we see people placing in revocable trusts are bank accounts, brokerage accounts, stocks and bonds, real property. And that's an important piece because real property is usually what takes the most time in probate. And especially if you have a second home or investment property in multiple states, that way you can avoid probate in those multiple states. Otherwise, with just a will, you would have probate in your primary state and then what's called ancillary probate in all the other states. So it really saves a lot of time and money and attorney's fees if it's those real estate pieces are retitled in the name of your revocable trust.
Great. Let's see. Can you offer some examples of POD distributions?
Do you mean like accounts or how they're distributed? A payable on death usually is offered like with checking or savings accounts at like a bank. And so what that would look like is you would list someone, let's say my account, I would list my husband, or a contingent beneficiary. If my daughter was old enough, I could list my daughter as a contingent beneficiary. And what that would look like is when I die, my husband would take a death certificate to the bank, let them know I've passed away, and then they would transfer that asset to him. I think that might be what you were asking, but it would just transfer to whoever you list. Let's say you did, if they allowed you to put 2 individuals, it could go 50-50 to 2 individuals, but it really just depends on the institution where you're at, how they let you designate the beneficiaries.
Okay, a couple more questions. Any cons for establishing trusts?
Well, the attorney's fees, I mean, you have to pay an attorney to draft it. So that is worth considering. And then you have to take the time to fund the revocable trust. And that could include additional attorney's fees, such as, a deed of your home into the revocable trust. But I would say in my experience and in our team's experience, that overall cost is going to be in work is much less than what your beneficiaries or your estate would pay after your death. And some people don't care about that, and that is fine. They'll say, I'm dead, I don't care. They can just do with it what they want. But then others say, I want to go ahead and take care of this now. Either options, honestly, fine, as long as you know what you're getting into and you know what you're choosing. So.
All right. We have one that I can actually answer. Does Baird have will creation services? And the answer is no. Your financial advisor may have estate planning attorneys they could refer you to, and we're happy to review that work and give you some advice beforehand about what you should consider having done. But we do not create any of the estate planning documents internally. If I don't have an immediate family member, who typically would I choose as executor?
Yeah, that's a great question, and one that comes up for a lot of folks. I would think about a friend. Some people choose extended family members like nieces or nephews, cousins, a longtime neighbor, someone that they're close to from their place of worship. And there are also corporations definitely in large cities, that will act as an executor for a fee. They'll act as an agent under a power of attorney. In some states, Baird Trust can even act as executor, and in others, they can be appointed as agent for the executor. So there are probably some local resources that can help connect you to an organization that will manage that for you for a fee. And for a lot of folks, that's worth it because they're a professional. So.
Right. For business owners, are there any special estate planning considerations?
Make sure your attorney has all of the business documents, because there are many special estate planning considerations for passing on that business interest either to your loved ones or your other business partners. So be sure to gather everything that was ever created regarding the business organization documents, and then give that to your attorney, because the options are almost limitless there.
All right. Great. Well, thank you both. We've got a few other comments. We'll address those as part of the follow-up after this recording's available. And again, thank you for your comments. Thank you for participating. And thank you, Darian and Jessica. I know we all hope you found this information valuable and we were able to address your questions. And if we weren't, we will we'd ask you to reach out to your Baird advisor and have them circle back with us. We'll make sure we get an answer to you. If you want to share today's presentation with a friend, family,